don't want to speak for long, but I do want to just remind all of us about the oath that all of us take when we accept the great privilege of representing our constituents here in the House of Representatives. We all take an oath to uphold the Constitution of the state of Michigan and the Constitution of the United States. And that includes a responsibility to oppose legislation that is on its face unconstitutional. Legislation that has been found to be unconstitutional at least once in the Supreme Court of the state of Michigan and in multiple lower courts. It was only, I think, a couple of years ago that I think I stood down there closer to the rostrum speaking on a very similar piece of legislation that was introduced by Representative McMillan that did the same thing. What this legislation then did and what it does now, it's just the price tag is a little higher this time, is it provides a shortcut in due process. It basically says that a business or an organization that believes that illegal picketing is going on outside its door can go to a judge, file a paper, and with virtually no evidence, get the picket shut down and get people fined. Now that is unconstitutional. Don't take it from me. You can ask the Supreme Court of the state of Michigan. So to help everybody understand that, and I spoke with the bill sponsor about this, and I'm not sure that he understood exactly how this process works. When somebody seeks a preliminary injunction, it's not like LA law or Perry Mason or so, I don't know what your televised example of due process is, but it's not a trial. It's not a full-blown hearing where people get to present evidence and there's an extensive process of vetting the truth. No, it's a quick process, and it's an opportunity for somebody who maybe has a snapshot or a video of what is supposed to be an illegal picket. It may be a picket that's been created or disrupted by a plant, by somebody who doesn't even represent the organization that's picketing. But they don't need very much evidence because they're not in a full trial. They're in a proceeding that is seeking where they're considering a preliminary injunction. So it is a very brief and very limited burden on the party that's bringing this complaint. So that's what you need to understand. And if anybody thinks that that's due process, that that's a fully fair and vetted process for deciding what the truth is, then that probably works in Putin's Russia, but it doesn't work here in the United States, and it doesn't work here in the state of Michigan. So the legislation, if you're up there green for this legislation, you're red for the Constitution. Remember that. That's what this vote is about. It's about what's constitutional and what's not. This is a denial of due process. This is a usurpation of the judiciary's power. This is the legislature dictating to the judiciary when it should be granting a preliminary injunction and removing their discretion. Because what the law says now is that you have to be able to show irreparable harm. And that's a significant thing you have to show. It's a significant standard you have to meet. And the reason they have that significant standard is we're not having a full trial. We're not having a fair opportunity for enough time and enough notice and enough opportunity for people to really put their cards on the table and argue over what's true. So that's why the court, time and time again, has said legislation like this has no place in our state. So I ask all of you, if you care about the Constitution, if you care about due process, if you care about not shilling the First Amendment in this state, not discouraging people, not scaring them, not dangling $10,000 fines over their heads, you'll vote no on this legislation.